much for joining us today. My name is Sarah Zabo, and I'm the Director of Plan Giving here at the Swedish Foundation. The foundation is the fundraising arm of Providence Swedish, the largest nonprofit hospital healthcare system in Washington State based in Seattle. I'd like to take the opportunity to thank our donors who are joining us today and our caregivers. Without your support, we can't continue the innovative work we do every day for our patients. This is the first of our two-part estate planning series. We hope you'll be able to join us on Thursday for our second session on trust planning basics. So if you're having any issues hearing the audio, please dial 253-205-0468 on your phone, and the webinar ID is 832-0173-5377. If you continue to have issues with viewing, hearing, and they're just not getting resolved, please email us at foundationevents@swedish.org, and we'll try to address them as quickly as possibly. And this information will also be dropped in the chat for you. This is being recorded and will be available for view at a later date. You'll be getting it in a follow-up email. So if you have to drop off, don't worry, you'll still get to see everything. This presentation will be about an hour and 30 minutes long, 30 minutes for Q&A. But if you have questions during the presentation, please add them via the Q&A during, and I will ask them for you. And what I can tell you is that if you have a question, probably other people have that exact same question. So do not be shy, pop your question in the chat, and I'll ask it as we're going. If you did not receive the estate planning guide in the mail and would like one, please let us know. We're happy to get one out to you ASAP. Okay, now that we've completed our virtual housekeeping, I am delighted to introduce our speaker today, Emma J. Luton, a state attorney at Gordon Thomas Honeywell. Emma has been practicing law for the past 6 years with a primary focus on estate planning and probate. She received both her JD and Master's in Laws and Taxation from University of Washington and is a member of the Swedish Foundation's Legacy Advisor Network. Emma is a Pacific Northwest native who, unsurprisingly, enjoys being out in nature in her spare time. Thank you so much for being here today, Emma. The floor is yours.
Thank you, host. I will unmute. I'll go ahead and pop on my slides and we'll get started. All right. So just so I know, are you guys looking at me and the slides or just the slides?
You okay. And the slides.
Perfect. That's really helpful because I like to talk with my hands, illustrate with my hands. So it's nice to know that you get the benefit of that as well. So this is estate planning basics. As Sarah said, I am an estate and probate attorney at Gordon Thomas Honeywell. I work out of both our Seattle and Tacoma offices, so you can always find me. To reiterate, please do ask questions throughout. We're going to be running this conversation today pretty similarly to how I have this conversation with new clients coming in. I'm going to follow it in the order that we normally discuss it, and you'll be getting a lot of that same information. Today, we'll start with what is estate planning. We'll highlight some key estate planning documents. We'll talk about planning for death first, because I find that that's often the top of people's priority lists. And then we'll move on to planning for life, which I think is the more important part, even if it's not on the top of your mind at this time. And then we'll round out with some estate tax planning information and some information about gifting, including charitable gifting. So what is estate planning? Here's the definition that I'm offering to you today. Estate planning is the creation of a plan for the management of your personal well-being and your assets when you are no longer able to manage them yourself due to death or incapacity. Importantly, this is not just a will, it's not just a living trust, it's not just documents, it's not just the legal piece, but it should really consider the practical considerations of how this is all going to work together for you. And it is not just a financial issue either. For many families, the most important thing is having the family relationships continue after a death, and then to support those family relationships. So while it is normal to have these conversations start with ideas about how assets should pass after your death, there's a lot more to it than that. And it absolutely should address your plans for incapacity. As I understand many of you are aware through your medical work, more and more and more in the modern world, we're seeing years of diminished capacity, either true incapacity, as in the case of guardianship, or just needing a little extra help. One of the things I'll reiterate again and again throughout this presentation is that your estate plan should be a comprehensive plan. I refer to myself as a comprehensive estate planner. It's not just I walked out with documents. It's really thinking through your entire financial picture, your family priorities, and the practical considerations. As an estate planner, I think that estate planning is for everyone. There is a hammer and nail situation here, right? If you're a hammer, everything's a nail. But some of us do need estate planning more than others. And here are some of the hot spots I see. There is an estate tax in Washington. So if you as an individual, or you plural as a married couple, have assets in excess of $2 million, there's some estate planning opportunities here that you could be taking advantage of. Federally, the estate tax threshold is right now about 14 million per person, and it can be combined for spouses. Where many people need estate planning is in the modern family situation, where we have stepchildren, we have blended families, we might have estranged children. In my family, we're a blended family. My older brother is my half brother. He's not related to my dad. If something were to happen where my mom passed away, my dad inherited from my mom, and then my dad passed away, state law says my younger brother and I receive, but not my older brother because he's not a legal heir. That's what I would call death order roulette, which is a unfortunate way to phrase it, but it does, I think, really highlight the potential problem for blended families in particular. If there's property in multiple states, there's a lot of opportunity to make administration easier for your family after your passing. We've talked about incapacity, that should always be addressed. And then there are other issues. You might have unique assets like business interests. Maybe you have a medical practice, a legal practice. Maybe you own interests in the family business. There should be a plan for all of that as well. Here I've listed some of the key estate planning documents. You'll see this is a long list, and there could be more that I could add. I could add a dementia directive. I could add life insurance information. I could add a transfer on death deed. So your individual estate plan might have some of these, it might not have others. That depends on your unique circumstances. But all estate plans I want to see for my clients, for the people on this call, include these three highlighted items: power of attorney for finances, power of attorney for healthcare, and a will, last will and testament. If you are someone who you have a living trust, you should also have a will as well. And then, like I said, we're going to be going out of order to discuss these, but this is to help you understand where in the scale of time these documents fall. So turning to planning for your death. When we're planning for your death, as I said, this is a comprehensive estate planning piece. Every single person already has an estate plan, whether they've prepared one or not. The background under the law is your intestacy plan, and that follows the law's best guess for you. So it goes down the up. It goes to children, then grandchildren, great-grandchildren if you have them, then up to parents, siblings, nieces and nephews, so on and so forth. For many families, that's the right fit. For other families, it's not. In my own marriage, my spouse's intestate heir after myself and my son is his father. I've never met his father. So this is where a customized plan through a will or a living trust could really be important. Another big piece of planning for your death is, what is it actually going to look like to make this happen? In many, many states, probate can be a time-consuming and expensive process. California is especially guilty of this. The California probate system is way overburdened. That said, I have clients who are Washington residents, lifetime Washington residents, never going to leave. All their assets are here in Washington, say, I want to avoid probate. And my answer is why? Probate here in Washington is incredibly streamlined. It's inexpensive. We don't go to court. You don't go to court. And what we find often is people with living trusts still need probate. Probate is really only one tiny piece of the full postmortem administration process. Whether you have a will-based plan with probate or a living trust-based plan, you're still going to have beneficiary designations you need to think about. You're still going to have a final income tax return. There may or may not be a state tax return. So these are all pieces of the total postmortem administration and total planning that I would want you and your advisor to be thinking about when putting together a plan. Some other practical considerations, maybe like me, you are the financial person in your relationship, and maybe your spouse needs a little bit of support to work through this process. There should be a plan for that support. Again, maybe there's special assets like a law practice or a family cabin that might need a little more attention. Maybe you have really strong feelings about funeral services, about last wishes. Those can all be attended to. Last piece on planning for your death and the comprehensive. I find that practical considerations are really, really important. I want things to be as easy as possible. So you'll see asset summary on this list. I encourage people to put together a short 20-minute high-level summary of their assets. I bank with BECU. My retirement's with Vanguard. You know, you can sit down and put that list together quickly as a guide to your family members. So what does a will do? For all people who have a will, you will be using your will to name your personal representative, which is what Washington calls an executor. That's the same thing. If your estate plan creates trusts, perhaps for minor children or surviving spouse, you'll name the trustee. I have an 18-month-old son, so my will names my younger brother, as it were, as a guardian for my younger son, for my young son. Wills give you the opportunity to make gifts of tangible personal property, things like art, cars, jewelry. It gives you a space to make specific gifts of specific assets. Often this looks like real estate or those family business interests or flat dollar amounts. And then the remainder. The remainder tends to be where the big piece of planning happens. Sometimes the remainder is 3 ways equally to my 3 kids. Nothing wrong with that. Sometimes a little more planning needs to go into it. Maybe there's a tax savings trust for spouse because of this Washington state estate tax. Maybe there's a trust for spouse because you and your spouse have separate children and you want to have a fund available to support your spouse, but you want to make sure anything that's left over goes to your kids. We have a trust, my spouse and I, in our wills, and that's because our not yet 2-year-old should never inherit money. It asks my mom to manage, any assets for his benefit. And it's typical to see trusts for beneficiaries with special considerations. Now, this says special considerations and not necessarily special needs, because absolutely, if there are special needs that require attention, your estate planner is happy to help with that. But it may be something else that's going on. Maybe it's that your child or grandchild is just terrible with money. Maybe it's that your child or grandchild has certain, is set up for college from a grandparent, and we're trying to serve other goals with this. It could be that you really don't trust your daughter-in-law or son-in-law and you want to put some protection on that fund. So special considerations can look like a lot of things. What I ask families is, what would set your family up for success? If the answer is, my kids are doing great, I'm not worried about them, I love it. If the answer is, well, they do need a little help, we can do that too. A note on here on wills. For the most part, you must have an original will for probate. Little asterisk, there's things you can do if it's gone, but you really want to have the original. So what we do in our office is we have blue accordion folders that we put the original will in and all the other estate planning documents. It's labeled original estate planning documents of Jane Smith, do not destroy. That's one way to make sure that when someone is going through their files, they don't throw something out on accident. The other thing we tell people is make sure your family members know where to look for these documents. I put ours in a envelope in our closet, and my husband said, well, obviously our estate planning documents are at your office. And I said, why would they be there? That's my job. And he's like, your job is to do estate planning documents. Why wouldn't they be there? You see how this is a problem. So one of those practical considerations, people should know where to look for those documents. Wills can be updated right up until the moment where you have capacity no longer. We're going to talk about that in a moment. You can replace a prior will one of two ways. You can modify it with a codicil. So you say, hey, I have this valid will from 2000, and I just want to make a change with my codicil. Both the will and the codicil have the same formalities of requirements. You still need two witnesses who are there in the room with you. You're all holding pens. You may also benefit from a notarized affidavit from those witnesses. What we often do in our office is we say, why would we do an amendment with a codicil if we can just do a whole new will where it's all together? There's pros and cons to that approach. But what I always want to make sure I see when someone comes to me and says, I have a will, is those two witness signatures. If there's only a notarization stamp on there, we have a problem and we need to revisit. I did flag capacity here. I do want to let you know that testamentary capacity, so the capacity to make a will under the law, is actually really surprisingly low. It's quite low. You need to know who your family members are. You need to know what your stuff is. You need to know that what you're doing is making a will. This is really important for someone who, for example, has a recent dementia diagnosis. Maybe you know that you're beginning to struggle. That doesn't prevent you from being able to update your will. Frequently, I will see people in my office who are struggling a little bit. Often I see people in my office who don't understand the legal jargon in their documents, which is fine. That's what my job is. But I do want to let you know that both for yourselves and maybe for your parents or your other family members, there is some leeway. You have to have these documents before you need them, right? If you've passed away, it's already too late. If you're fully incapacitated, it's already too late. But just because you're beginning to struggle doesn't mean that it's gone.
We have one question, Emma.
Mhm.
What is a codicil?
Absolutely. So a codicil is specifically the name for an amendment to a will. You would never make an amendment to a will, you'd make a codicil. Same thing. Often you would simply do a new will, but there are reasons to do a codicil as well. The execution requirements for both are the same. That's one of the things I want to flag. You can't execute your will in your lawyer's office with 2 witnesses and the whole show, and then go home and quickly do an amendment without the same formalities.
Thanks.
All right. So one of my great fears as a planner, and again, a comprehensive estate planner, is that people will come to my office, we'll have these conversations about their goals, their priorities, their families, their wishes. We'll get into the nitty-gritty of their assets. I'll put together this estate plan. We'll execute their documents. They'll walk out and it won't matter. And it might not matter because your beneficiary designations supersede your will. So what does that look like? Let's say, I'll use myself as an example. Let's say the year is 2019 and you just got married, but you have not updated your beneficiary designations, so your brothers are still listed on all of your accounts. It doesn't matter what your will says, those counts will pass pursuant to the beneficiary designations. Some footnotes here on marriage, but the idea still stands. This gets people in trouble if, for example, there's a marriage, things like that. If there's divorces, this can be an issue. I've also seen situations where the beneficiary designation was set up when the company maintained paper files, and then when they went to digital, all those records just got wiped and they were never set up. So this is something that my office spends a lot of time on, making sure that your whole plan fits. Here's another red flag. Another place where this becomes an issue is, again, I have a young son. If I name my son as recipient on my life insurance, well, there's going to be a very large check going to a very small young person. What actually needs to happen is the life insurance needs to go to the trust for my son. And we work through these processes with clients. That's part of what I would hope any estate planning attorney would do. Our office always does. Sometimes these bite people not because they weren't watching them, but because they didn't realize what the bank was doing. A fairly common issue is people will add a child, an adult child, to an account for convenience. You know, hey, Tom, I just need a little help paying my bills, making sure things getting taken care of. Maybe I'm traveling a lot. I'm going to add you as a signer on my account. Well, often banks, for various reasons, won't add Tom as a signer. Often banks will add Tom as a joint tenant with right of survivorship. What that means is Tom suddenly becomes a equal co-owner in the account and the sole beneficiary. Maybe that's fine. Maybe Tom is your only kid and you don't care. Maybe Tom has some conflict with his siblings and all of a sudden this matters a lot. So one of the things that we flag is this issue, and that there are other tools to achieve the same goal, that tool being a durable power of attorney that we'll talk about later, without the potential issue here. We've covered a lot so far: wills, key documents. I've got a lot more for you, but if there's any burning questions, I'm gonna ask you to pop them in the chat here while I take a quick drink. Not seeing any burning questions. All right, feel free to pop them in at any time. So we've been talking about a will. When a person passes away, assuming they have a will, and a fairly similar process if they don't, what happens is that will gets submitted to the probate court. The probate court says, okay, this person is going to be the personal representative, which is what Washington calls an executor. And then the court issues letters testamentary. Now, letters testamentary, that's your card. That's your authority that says I can do stuff. The process I just described of getting court authority is probate. There are other parts of administration that are not probate. They are just part of administration. We talked about that. Income tax returns, dealing with beneficiary designations, perhaps selling the house, often cleaning out the house and then selling the house. None of that's probate. That's just administration. That said, people do come to me seeking to avoid probate. There is cost to probate. There can be delays to probate. In my experience, for people who are committed Washington residents, I'm an example of this. I was born and raised in Washington. My spouse and I were never moving. This is where we're going to be. We often find that it's not worth it. And here's some of the red flags for the most common techniques we see. Sometimes people will use beneficiary designations to try to avoid probate. Maybe they say, okay, my retirement goes to child A and my home goes to child B, and they're both worth $300,000, so it's perfect. Except that what ends up happening is the home is slowly accumulating in value, and the retirement is slowly being dwindled down. And also that retirement has income tax on it. So when the estate finally comes to fruition, matures, when a person passes away, one child ends up with a $500,000 home and someone else, the other child ends up with a $150,000 IRA with income tax. So things that made sense at the moment end up shifting over time. Another big benefit of probate that could be especially relevant for the medical providers in this room is that it clears creditors. So there is always statutes of limitations running for any potential claim. The statute of limitation for death supersedes that. From the moment of death, there's 2 years for a creditor to bring a creditor claim. If you use the appropriate probate process, that 2-year period can get shortened down to 4 months for most creditors. This is really, really valuable, especially for people with a high risk of being sued, like medical professionals, like attorneys. And if someone came to me with a perfect plan that avoided probate, I might open a probate just for this in some cases, because the probate process here in Washington is simple and efficient. So you'll see advice out on the internet about avoiding probate. It's great advice for some people in some states. It may not be appropriate for you. I'm seeing some activity in the chat, Sarah. Anything?
So one thing I just want to verify is that people need to put their questions in the Q&A, not in the chat.
All right,
So
I wouldn't see
sorry,
you anyway.
sorry for that. But yes, sorry.
All right. So that said, maybe it is appropriate for you to avoid probate. Maybe there are other reasons for non-will based plans for you. One of the most common non-will plan is a revocable living trust. Excuse me. You'll hear them are called living trusts as well. But I like to use the full name revocable living trust, and that's because the most important word here is revocable. So long as you have the ability to modify it, to terminate it, to make any changes to that trust, it is you for tax and creditor purposes. This is a really common misconception. You'll hear people say things like, I put stuff in my living trust for creditor protection. There is no tax or creditor protection that can be created through a living trust that you couldn't get through a will. It's just you. I like to think of it as your alter ego. Now, it is true, and we'll be talking about this a little more, and we'll be talking about it in greater depth on Thursday at the trust session. It is true that an irrevocable trust that has been set up by someone else for you or by you for someone else, it's true that those have creditor and tax protection, but that's not the tool we're talking about here. And the way that this works as a probate alternative, as a will alternative probate avoidance tool, if you were to use it that way, is that when people die, you need probate. That's just the way it works. But trusts don't die. So what you do is you create this revocable living trust, and you put all of your assets in that living trust. Your home is titled in the trust. Your bank accounts are titled in the trust. Your qualified retirement often isn't. But everything else is your business, your everything. It's all in the name of that living trust. So that when you pass away, you don't actually own anything in your own name that would need to pass through probate. This piece, this funding piece, is sometimes a gotcha for families. They'll either get it all funded correctly the day that they set it up, and then over time, things will get missed. Maybe assets are bought and sold, they moved. Or in really unfortunate scenarios, they set the living trust up on day one and then just didn't fund it at all. If assets are left outside of the living trust, probate might be required anyway to get them back into the living trust. That said, there are some really wonderful non-probate related reasons to do a living trust. One of the biggest ones is a privacy benefit. Wills become public records upon your death. Revocable living trusts don't. If your will says I leave everything to my spouse and then my kids, it's impossible to know if you have $5 or $5 million. But if your will says I give $500,000 to the opera and $500,000 to the Fluffy Animal Society of America and $500,000 to this charity and that charity, pretty quickly you can see what someone's assets might look like, and that's just a lot of information to have out in the world. Another really, really valuable non-probate related use of a living trust is if you own real estate in more than one state. Now, maybe you're like me, you're a designated Washingtonian, you're never leaving, but you do have that place in Palm Desert. Create a living trust to hold just that Palm Desert property so that you can avoid the California probate that comes with it. Maybe you're not like me. Maybe you really truly split your time between these two places and you may choose to retire somewhere else full time. Maybe in that case, it makes sense to put everything in a living trust, knowing that you're likely to move down the road. These are all alternatives you can discuss with your advisor. They're all good choices depending on your unique circumstances. For a living trust, another benefit of it for the right circumstances is when you set them up, most typically the person who sets them up is the trustee who manages it, right? You're managing your own stuff for your own benefit. But then in that document, you name a successor trustee. If I am passed away or no longer able to manage, I want this person to step in. It can be really, really elegant if you have all of your assets already owned in the name of your living trust, just to have one person step in as trustee and take over management. It can minimize hiccups, make things move more smoothly. So that's another potential benefit of that. And I suspect they'll be discussing this a bit more on Thursday as well, but I'm happy to answer questions on this because it is a powerful tool for the right circumstances. Community property agreement is another probate avoidant tool. Washington State is a community property state. What that means is that unless there's a different arrangement in your marriage, the assets that you earn from your labor, so your W-2 income or perhaps your work in your business, not the business itself, but the work that you produce from your labor, is community property. It belongs to you and your spouse as a unit. Well, here in Washington, we have the option to create what we call a community property agreement, and it has 3 prongs. You can mix and match them, but a full 3-prong community property agreement does the following. 1, it converts all property you own right now to community. So let's say you come into the marriage with some stuff. This first prong would make that separate property you came into the marriage with community that you share. The second thing it does is it makes all future property community. So I am likely to inherit some money someday when my parents pass away, hopefully decades and decades down the road. I could say today, you know what? That's all community. It's going in the pot. Whenever it happens, it happens. And then the third prong, this is the really tricky piece here. The third prong says all community assets, which is of course everything now, passes automatically to my surviving spouse without probate. You can see how this could be a really powerful tool. It just all passes to the survivor. There are some problems with here. If there's a taxable estate, if you together have more than $2 million, this could forfeit some opportunities to do some estate tax planning. This could create problems with blended families like mine, where you have the gotcha. If my mom passes first, my older brother gets inherited. If my dad passes first, then it splits equally between the three of us. And it cannot be revoked by only one spouse. Now, this seems a little silly because you're thinking, well, obviously we'd revoke it together. But my fear here is we filled out a community property agreement in the 90s. It totally made sense. We had $7 to our name. Perfect. But now time has gone on. Our assets have probably grown over the years. And now we need a little bit more complicated planning, but one of the spouses is now incapacitated and not able to revoke to do the more advanced planning. So something to be aware of. It's kind of a blunt tool. It really only does the one thing. It does it well, but maybe it's the one thing you need. If this blunt tool isn't the thing you need, and if you're sitting here thinking, wait a minute, I'm not really sure which of our assets are yours, which are mine, and which are ours, the community property agreement's cousin is the property status agreement, where the two of you sit down and you say, well, yeah, that account's yours, and that account's mine, but the house is both of ours. And actually, this is, part mine, part you sit down and you lay it all out. What I find is spouses are pretty good about sitting down and sorting this out, but where you get in trouble is if the next of kin to those spouses are fighting over it. So for example, I was once involved in the litigation of an estate in which the deceased person's will says I leave all my community property to my spouse, second spouse, and I leave all my community property to my children from my first marriage. But there was no property status agreement in place to clarify which asset went into which bucket. So the second spouse and the first set of kids spent 2 years suing each other. That can be avoided. And one of the things, yes, please.
We have a couple questions about,
Okay.
So first question is, what if we don't have a trusted friend or family member to act as our executor, POA, post, etc.? What would you recommend?
Great question. I have a whole slide on this at the end, but let me jump into it now because it is a real issue. I spend a lot of time on this with my clients. Some people have an obvious go-to choice. Maybe they have a lawyer in the family. A lot of people don't. So your advisor would sit down and work with you to say, well, is there someone that we can get involved? What would make sense? There are also professional trustees available. And I talk about this with my clients as well. On the scale of sort of formality, the most informal professional trustee might be, you know what? I have a third cousin who's a CPA. I bet I can pay him to do it. Or maybe I have a really good relationship with the CPA, something like that, where it's not a friend or family member, really, it's a professional, but they're taking it on for you. On the most formal, most structured side, I would say that tends to be big banks. Most big banks have a trust department, Columbia Trust Services, US Bank Trust Services, on and on. And then within the middle, there are individual professional trustees. Sometimes this is attorneys who, this is what they do. They administer trusts and estates and power of attorney. And there's also small chartered trust companies. So they're still a regulated industry like banks, but they're not in banking. They are in trust management. So I work with clients to sort of recommend where along those scale a professional might fit. And that depends on a lot of things, where they are, what kind of services they need. Do they really need touchy-feely personal connection, or do they really need someone to manage money primarily? That can be a tough spot, but it's not a unique spot. And there are options available that an estate planning attorney who talks about this stuff can help guide you through.
And I know Emma will talk about this later, but even people that have trusted family and family members still use professional executors and fiduciaries. So it's not just if you're in that situation, and she'll discuss that a little bit later. We also have another question about the type of assets you might put into a revocable living trust. The question is it advisable to maybe not put your qualified retirement account into a living trust and instead pass them directly to heirs or beneficiaries, or how can that work?
Absolutely. So I recommend not putting qualified retirement in the living trust. There's all kinds of rules for qualified retirement that we want to make sure we're checking those boxes. And like you've already flagged, they pass by beneficiary designation anyway. Qualified retirement is something we talk about a lot because it has its own special rules, right? That's why it's qualified retirement. You got to check the boxes to get the benefit. So we're going to be talking a little bit more about that asset in particular, opportunities for charitable giving with that asset, red flags and financial, when I see someone's financial statement, here are some of the things I'm looking for. I'll flag retirement accounts as one of the pieces of that puzzle. So the short answer is yes, retirement outside living trust. Long answer is see more on retirement later.
Great. On you go.
All right. So we just covered a lot, very, very high level discussion of a lot of key things. So I'm just going to take a moment before we move on to pause and recap. We talked about the 3 essential documents. We talked in detail about last will and testaments, flagged that there are formality requirements. This is something that should be done properly in our office. We always do them in person, either in our office or in the client's home, because we want to make sure they're done correctly. And that the other 2 key documents I want to see for every single person is a power of attorney for finances and a power of attorney for healthcare. Moving on to that next. We talked about will alternatives or perhaps will supplements, depending on your unique situation, the revocable living trust, the community property agreement or property status agreement, and beneficiary designations, and how all of those pieces should be working together for one comprehensive plan. We've talked a little bit about what estate administration can look like. It can look like tax administration. It can look like dealing with real estate. It can look like closing down a business. It always has a last income tax return. It may have an estate tax return, and it may or may not involve probate. In my experience, the vast majority of estates are both probate and non-probate. That's what I would expect to see, the 2 sets of plans. With that, let's move on to a deep dive on power of attorney documents. So durable power of attorney for finances. This designates your agent to make financial decisions during your lifetime. Agent is the term now in Washington. It used to be power of attorney. Effectively, it's the same thing. Agent is the term now. And they make decisions for you No, let me back up that thought. Who make decisions for you during your lifetime. These documents can be set up to be effective one of two ways. So they can be effective immediately upon signing, or they can be effective, what we call a springing durable power of attorney, effective upon incapacity. For the vast majority of my clients, our clients, the attorneys here at my firm, we recommend effective immediately. And we recommend it effective immediately because what we tend to see is that people benefit from help before they are legally incapacitated under the law. So as we all know, in our experience with family members and whatnot, capacity exists on a scale, but the law sees capacity as a switch. You have it or you don't. So I like an effective immediate document so that if someone is struggling and could benefit from help, they have access. But there are other situations where the power of attorney for financial document is really valuable. What I see quite frequently is people who have all the capacity in the world, their minds are sharp, they just can't hear, or they can't get to the bank, or they just aren't comfortable navigating the online portal. Power of attorney for finances that is effective immediately would allow them to get help with that. Another key piece here is sometimes you are not incapacitated under the law, but you are temporarily in need of support. Perhaps you have a planned surgery or an unplanned medical accident, and you just need someone to take care of the insurance company conversations while you're recovering. Power of attorney for finances really is a powerhouse document. I mean, they're simple from a drafting perspective. For me, we do them all the time. But what they really do is they allow someone to take over without the need for a formal guardianship. And the problem with the formal guardianship is, one, again, you need to be incapacitated under the law for guardianship to apply. Two, the court picks your guardian, you don't get to pick. Guardianship, if a guardianship is declared, you do lose certain rights. But most importantly, they're expensive and they can cause conflict between family members. Maybe no one wants to be the guardian. Maybe everyone wants to be the guardian. Maybe the right choice for guardian actually isn't able to act. Maybe there's a history, a felony record from when they were in their 20s that has nothing to do with their ability to take care of mom or dad, but could prevent them from qualifying. We don't need that. It's expensive. It's stressful. I want better for you and your family. Much like power of attorney, again, executor, professional fiduciaries are available. Sometimes a professional fiduciary is the right choice in this role because there's no one else who's a good pick. Sometimes a professional fiduciary is the right choice in this role because you don't want to make someone else do it. Maybe it's just unkind to give that particular task to a friend or family member. And a power of attorney for finances is effective during your life only. So sometimes I see people try to use their power of attorney in lieu of probate administration. It doesn't work that way. It goes up till the moment of death, and then the will or the living trust kicks in.
We have one question for you very specifically. Are you taking on new clients, Emma?
I am always taking on new clients, but our firm, we work really, really closely. So when we get a referral, any one of the four of us gets a referral, we work together to find the right attorney fit for them. So I, for example, don't do guardianship work. If someone called in saying, there is a guardianship in place or we suspect one's in place, that'd go to my colleague, Jeff Nielsen. So yes, I'm taking on clients, but even if you called for me, we might suggest that another person might be a better fit for you.
Great, thanks.
Yep. Power of attorney for finances. This is my whole slide, but I want to pause for questions here because this is a really powerful document. Again, it was on my key documents list. If you have questions, I want to talk about them because this matters. This matters a lot. Your will, you're already dead. This is your life. So
We do
If
have
you have
one
questions, now's your
question.
time. Yes, thank you. Yes.
Here we go. Can durable power of attorneys makes tax decisions that ultimately benefit themselves if the maker wants this to happen?
Um, the short answer is yes. The longer answer is, in my practice, I never talk about taxes. I always talk about estate taxes or gift taxes or income taxes or property taxes, to make sure that we're really clear on which taxing regime we're in. The power of attorney for finance documents I set up, in many cases, have gifting powers. So many of the documents I set up specifically contemplates, for example, deathbed gifting. So Washington State doesn't have a gift tax. It does have an estate tax. It can be really advantageous, both in terms of estate tax avoidance, but much more importantly, estate tax return preparation, to make a large gift right before someone passes away to get below that threshold. Um, in my opinion, a little bit of estate tax is a meh, but 2 years of your life back to not have to deal with the estate tax is a big win. So that would be one example of the agent making a tax-driven decision that could benefit themselves if you're actually the child who is the agent who is gifting to yourself in lieu of the inheritance you would have received yourself. It sounds like this might be a more specific question, but that was one example of how taxes could play out here if it was truly in the best interest of the principal, the person who set up the power of attorney, and the principal's wishes. Other questions for me, Sarah?
And just kind of on that take, do you often see a person who will benefit in a will be the durable power of attorney for their partner or someone during lifetime? So that happens sometimes.
I frequently see that. I frequently see the named agent be someone who would benefit in the will, because for many families, you are naming your kids as beneficiaries and you are naming your kids as agents, right? That's a pretty typical way to do it. Or perhaps you're like me and me before I had my son, and it was, my husband and then my brothers. Same thing. You name your husband and your brothers. So it's typical to see them in those same roles. Um, then the question there is this person truly acting in my best interest or the whole family's best interest? And we'll talk about this when we get to the fiduciary slide. If you have any concerns that this person might go off the rails and abuse this power, why are you thinking of naming this person, right? The other sort of sub question I saw in there is, do I see it frequently? I frequently put the power to gift in. I much, much less frequently see that power actually be used. And I think part of that reason is when you're in an end of life situation, emotions are running high and no one's thinking, I should be making a tax advantaged gift. I try to flag it for clients. I try to flag it for their family members. And now I'm flagging it for you. This is, again, it feels very crass, but what it really is an administrative gift to your family, not having 2 years of dealing with the tax authorities is a win. So no, I don't see it often done, but it's there. It can be done.
So we have another question about professional fiduciaries that I think you're going to go into a little bit later, but she says they are lawyers or tax agents or financial people, bankers, or they can really be anyone. Is this true?
Um, Well, you see trust companies associated with banks. So in that regard, they might be bankers. You see people who work in chartered trust companies. You see individual professional fiduciaries who are licensed as accountants or licensed as attorneys. They have this sort of prior life in finance. So there really isn't a limit on who can be a professional fiduciary. It's not like it's a licensed position, like, you have to be an attorney to be an attorney. You have to be a CPA to be a CPA. You can be a tax preparer without it's, but if someone who did not have that background just said, I'm a professional fiduciary, I would have questions, follow-up questions to confirm that they are in fact qualified for that role. Now, lay fiduciaries, family member fiduciaries, that can be anybody. If you're not paying them, name whoever you want. Name them wisely, but name whoever you want.
Okay, so their background could just give you some thoughts about whether they are fit for the role, but it doesn't mean they might not be qualified, especially if
Correct.
they're lay. Okay. Great. That's it
You
for
know,
me.
and maybe they worked at a professional fiduciary company for years and then they went solo. That would be a non-lawyer, non-CPA person who I would not have concerns about.
Great. On you go.
Sounds good. All right, our next document is one that I understand we have healthcare providers in the room, might be familiar to some of you. The power of attorney for healthcare. The power of attorney for healthcare and power of attorney for finances can be a unified document. Many firms create them separately. Ours creates them separately. And I have a couple of reasons. One reason is the person who's the right choice for healthcare decisions might not be the right choice for money decisions. It's that they don't have to be the same person. The other reason is the less information you give the banks, the less likely they are to get confused. So we like to segregate out the healthcare stuff so we're not confusing the bank. That sounds flippant, but it's not. That's a real problem. Your healthcare power of attorney is effective immediately as to a HIPAA waiver. So the idea is I need someone who can give authorized consent or withhold authorized consent or otherwise make healthcare decisions for me if I am no longer able to make them or communicate them. But baked into that is I need that person to be able to talk to my doctor about whether or not I can in fact make healthcare decisions. So there is a HIPAA waiver baked in. And at such point as you are no longer able to make those decisions, your healthcare decision maker, your healthcare agent steps in and does that for you. As a legal document, that's really it. This is the person who should make healthcare decisions for me. But we want them to make the decision that you would have made, right? So we encourage our clients, I encourage anyone to talk to their agent, to their family members around their healthcare priorities, especially their priorities about end-of-life care. Maybe you are a proponent of alternative medicine and you want that to be something your agent always looks at. That should be communicated. And not just to your agent, but to other people who might be watching what that agent is doing and judging. My spouse knows I feel very strongly about acupuncture, but does my brother also know this, so that there's reducing the opportunity for conflict there? I've included some resources here on some tools to help think through end-of-life decisions. Being mortal, medicine and what matters in the end is a pretty detailed exploration of navigating healthcare options in an end-of-life context, because it does come for us all. So that can be a really powerful place to begin thinking through it and begin having those conversations. End of Life Washington End of Life Washington works primarily with the Death with Dignity Act, which Washington does have one. But I really like their website because they have really, really detailed directives for healthcare, especially for dementia, Alzheimer's, things like that. So that can be a really powerful tool for thinking through where you want care, who you want care, what your priorities are. It covers things like, who do I want providing care? Family members in all cases, family members, but only if they're paid, only professionals, things like that, that it might be important to you. But it also covers things like, if I no longer have capacity, if I'm advanced in my dementia, I do or I do not want to continue sexual relationships with my spouse. One way or another, it's probably a good conversation to have while you can still have it. So I know there's healthcare providers in the virtual space we are occupying. If you have anything that you think I could add to this list, please let me know. I'd love to flesh this out. But this is my my pitch to have those conversations while you still can. The cousin of the healthcare power of attorney is the healthcare directive. This is another document some of you may be familiar with. Washington has two main end-of-life documents for healthcare. One is the healthcare directive and one is the POST. The POST, which stands for Physician's Orders for Life-Sustaining Treatment. It's a neon green document. It's prepared by your physician, and it's pretty specific about care. Frankly, it's a good thing lawyers are not doing that. I cannot prepare a POST, nor should I. That's not what I'm trying to do. The healthcare directive is much, much more limited to a POST. I would not consider Do Not Resuscitate, because the healthcare directive does not kick in until, one, you are in a permanent coma, or two, you have a terminal condition and also cannot direct your own care. So you have terminal lung cancer and also are unable to communicate your care wishes at all. By signing the healthcare directive, you're indicating that in either of those circumstances, you would wish for artificial life support to be withheld. It does communicate the wish for continued care for comfort purposes, keep me hydrated if that's appropriate, give me morphine, more painkillers, more better. I want to make sure that this document matches the other documents you filled out with your doctor. So if you have a healthcare directive and a POST, they should be consistent between the two of them. The document that we have is fairly limited. Again, because we're lawyers, that's really the only circumstance where it can apply. But sometimes you see creative stuff like, my son's actually active duty military. This is my wish, but I also wish for him to have time to get home. Cool, let's put it in there. Let's make sure everyone who needs to know knows that this is your wish. There was another thought and it has escaped me, but stay tuned, it might come back. So my thought on this, here it is that this document is really a gift to your family members. It would be my wish that I never have to make this decision for someone else. So, whatever you want to do, I don't care, but please do it. And then a footnote, again, I know that we have healthcare providers in the room. It cannot be witnessed by a healthcare provider. It can be notarized. I understand that Swedish has notaries in the building. Healthcare providers cannot witness this for their patients. I'm organizing this under the end of life flag, disposition of remains. Here in Washington, the default for disposition of remains is burial. There are other options: cremation, organic reduction, hydrolysis. Of these, cremation is the most common. That will probably not surprise you. Funeral homes might require the agreement of all family members to cremate. Maybe that's not a problem in your family, but maybe it is. This can be a really powerful tool if you suspect there might be conflict among either your wishes and the wishes of your immediate family members, or among your immediate family members. There are horror stories in my profession about, son one and son two, one wanted cremation, one wanted burial, and so we were stuck in limbo for months. We don't want that. Unfortunately, one of my colleagues has remains in his office right now while the family members are fighting over who gets to keep them. So again, that can be avoided. It goes here, I want them spread there, can go a long way towards resolving those problems for family members. Another important piece of this is you can instruct the funeral home and other involved parties to whom they should be releasing remains. This could be really important if, for example, your person is not your legal next of kin. So maybe you have a long-term committed partner who's not your spouse. The first attorney I ever worked alongside was a same-sex gentleman who did a lot of work with the same-sex community before marriage equality came to Washington. This was a big deal because long-term committed partners were not spouses under the law and didn't have rights to those remains. So that's another piece where this might be important for you. I also like to use this document as a way to record wishes for funeral and memorial arrangements. Maybe you qualify for a military funeral and you want that honor. Cool. Put that information in here. Maybe you strongly prefer religious service or strongly prefer a secular service. Cool. Get that information down, let everyone know. If you've already pre-bought a burial plot, if you've already bought a cremation plan, that information can go in here. So it's all in one place. Footnote on this is not the place to make a gift of your body to science. If you've ever done time in the cadaver lab, anything like that, and you want to support that scientific inquiry, that should be set up directly with the institution ahead of time. So with the UW lab or whichever institution you want to work with. Whew, okay, so let's take a pause before we jump into this one. We've talked about all the key documents I'm highlighting today. We've spent some time on durable power of attorneys. We spent some time on end-of-life wishes, on communicating with your family members, both in writing or interpersonally, making sure everyone's on the same page. I'm going to take a drink here. So now we're going to jump into the last section, which are things we should be talking about in this discussion. And choosing fiduciaries has already come up as a big one. In a perfect world, we would all have a trustworthy, organized, fair, financially competent person with available free time who is local to us, who is happy to serve in this role. Wouldn't that be great? These are the characteristics we're looking for. Please don't name your oldest child just because they're oldest. When I review documents prepared by anyone other than me, if I see that the kids are named in birth order, I always make a point to ask, is that the actual order, or are you just concerned about hurting the oldest feelings? And if there really truly is no one in your life who fits this, let's talk about that. Let's see who we can find in that role. Fairly frequently I'll hear, well, I want to name both my kids. I don't want to leave one out in the cold. I don't want them to feel like I'm choosing a favorite. I understand that concern. In practice, having two people share the job makes it twice as much work, not half as much work, because what you end up seeing is the bank has now required both of you to sign, and you both need to deal with that check, and you both need to deal with all of these things. which makes it that much more difficult to move forward. So I strongly, strongly encourage you to name only one of those individuals, not two. I will, in my documents, sometimes, if this is a real sticking point, write something along the lines of, without reducing their authority in any way, please talk to your siblings. I would wish that you would communicate as to important decisions. It's not legally binding in any way, but it at least communicates that it is your wish for them to take this on as a team. One way to potentially deal with that. Also, alternates matter. I always require my clients to give me 2 alternates. I always want, well, yeah, a first and then a second alternate. I always want to see 2 names. I strongly request 3 names. Sometimes you name the person who you think's the right choice, and then you name a professional afterwards. And I always strongly want to see at least one of the names in that list be someone of the next generation, someone who's significantly younger. So if I name my brothers, the third person on that list should be my adult niece or a young cousin or something like that. We don't want to be in a situation where 80-year-old siblings are all naming each other, because at some point there will be a last person standing. Professional fiduciaries are available. I'm not in the business of professional fiduciarying. I'm not a professional fiduciary, but I think many people never consider that they're the kind of person who needs one, right? I don't need a professional fiduciary. That's for rich people. That's for weirdos. That's for people with complicated families, whatever that's for that you might have in your mind. And I do want people to think that it might be the right choice for their family. Like estate planning, it might be that it's an investment rather than a cost, and maybe it's just that your kids are all super duper busy right now. They have businesses and young children and careers, and the kindest thing you can do for them is get a professional involved, not because anything's wrong, but because everything is so right. So don't count that out if it sounds like it might be the right fit. Whenever we're talking about fiduciaries, there is always the fair question, well, what happens if they run off with all my money? Well, first of all, if you are already thinking this person might run off with all my money, why would you consider naming them? My younger brother, I cannot imagine a situation in which he would run off with all my money. My older brother, who I trust and love, I can imagine a situation where maybe my sister-in-law got involved and things were said and weird decisions got made and money was spent in a way that I wouldn't approve. He's not a bad guy. I love him. I trust him, but I can foresee not the plan I would wish for. Maybe I should just not name my older brother. Whenever someone is acting in a fiduciary capacity, it is almost always the case that there's someone else watching. So if my younger brother were managing my estate on my behalf, my older brother would probably be paying attention. My parents would probably be paying attention. My close friends would probably be paying attention. Sometimes you see involved neighbors, especially for elderly people who have close-knit communities at home. We'll get calls, hey, just want you to know, like, I've met Cheryl's son, and the guy coming over to her house a lot is not him. Just thought you should know that's kind of weird. Well, then we look back, we see that, your agent is actually your son, and you are effective immediate, and we can bring him into the situation, and we can start asking questions about what's going on. It is true that power of attorney has led to some elder law exploitation. That's a real thing. It happens. What I will say is it happens less frequently than people are worried about. The the concern for exploitation is much higher than the incidence. It still does happen. It might be that the right tool for you is to be more specific, more narrow about what is authorized. We talked about deathbed gifting. If you are not worried at all, do whatever makes sense for the family, maybe that makes sense. If you know there's conflict between family members and no matter what decision kid A makes, kid B is going to be mad, maybe you don't give them that authority. So that can be tailored to fit your unique needs and situation. A third category of people who are watching is your financial advisors watching, your CPAs watching, your lawyers watching. You only see me once a year, but you see your financial advisor a lot. So there are people looking out. I will also say this is a big deal among estate planners. We are always looking, one, to make sure that the person we're talking to really truly understands what's happening and wants it. And two, that there's no one more involved than they ought to be. So the way we phrase this is, I have no problem with a child facilitating a meeting with a parent, but they are not in the meeting. They are not leading the meeting. They are not calling the shots. So estate planning attorneys are looking for this as well. Another really common conversation we have with clients is about avoiding disputes in their estate. Gold standard, all my kids are equally successful and equally capable and married to equally wonderful people, and I have no concerns, and equally to everybody. That would be great if that was the plan for everyone. It isn't for everyone. That said, the more unequal treatment is, the more careful you need to be. Let's say you do want to disinherit a child, and maybe it's because they're doing really, really well. More often it's because of family concerns, behavior concerns, things like that. Maybe you don't disinherit them all at once. Maybe in 2025, you disinherit them a little bit. And then in 27, you disinherit them a little bit more. And 29, you disinherit them a little bit more. So there are tools available to make sure that your estate plan looks the way you want it, while also supporting having your estate plan play out in the smoothest way possible for the parties involved. Another thing I've done where to avoid disputes where children aren't receiving equally is you leave the will or living trust alone. Everyone receives equally under the will or living trust, and you make gifts during life. Does that still risk hurt feelings? Absolutely. But at the end of the day, the final letter everyone's receiving says, I see you all as equal. So that can be a way to get to an end goal that is maybe more palatable to your family members. Avoid disputes by having your documents executed correctly. Like I said, I want to see those 2 witness signatures. They're often, I'd say in most cases, is a self-proving affidavit or declaration attached that is notarized. I want to see that too. That's really helpful. If you look at your will and you're like, this was kind of weird, maybe I did it in a parking lot. That's what we did during COVID. Maybe it's a little weird, they mailed it back and forth. That might be worth taking a look at. Regularly reviewing beneficiary designations. Again, this can prevent a lot of disputes where what you wanted is not what matched. I encourage everyone to review all of their beneficiary designations annually. It's like replacing your windshield wiper blades. Just set a date on the calendar and do it. I do it in January. It's very boring, but I do it every year. Maybe the day you pick is your birthday. Maybe it's the date of your divorce anniversary. I don't know, but make a commitment. Another great way to avoid disputes is to clarify what's community and separate property. Again, it might not be that you and your spouse have any dispute, but that we want to make sure everyone who's involved knows what's what. That can be done with a short written agreement. The gold standard for that is you each have separate counsel review that. what you see pretty frequently is couples will come in to do their estate planning together. There's nothing wrong with joint representation. We do it all the time. If you said, hey, we want to do a property status agreement and clarify this, your attorney can talk to you about if the gold standard is a gold standard, or if no, really, this is an essential item for you, right? And it depends on your assets and what's at stake and who the parties are. And, you know, sometimes the bronze standard is enough. But of course, my job is to try to talk you into the gold standard. Please always think through the possible scenarios, especially with stepchildren. I use the example of my half brother here. In my mind, when I think of estate planning, when I think of beneficiary designations and who's listed as joint tenants right of survivorship and what's in the will and, you know, who's the recipient of my retirement account, what I actually picture in my head is like a Plinko board almost. Where does everything fall at the end? This is the picture I have in my head. What I'll do for clients is I will sit down and I will do a spreadsheet with the asset down the side and who receives it along the bottom. And then, you know, this goes here and that goes there, and it all adds up and we see who gets what at the end. Now that might be really complicated and you might be like, Emma, my life's not that complicated. Great. I love that. More simple, more better. But maybe you have a blended family, maybe there's been some lifetime gifting, maybe you helped one child get into a house, but the other child's living their best life traveling the world. That could be one tool to help you think through the whole comprehensive picture. You'll hear a lot of stuff about no contest provisions. You'll also hear about leave someone $1 so they know they weren't forgotten. I personally am not a fan of the $1 thing. I tend to make sure someone knows they're not forgotten by specifically calling them out. So it might say something like, I have intentionally chosen to leave no gift to my spouse because they have all the money they need. It might say something like, I have intentionally chosen not to leave any gift to my child, period. It might say, I've intentionally chosen not to give any gift to my child because I have other priorities or whatever. The $1 thing, not something I'm a fan of, but you'll hear about it. You'll also hear about no contest provisions. This can help deter a frivolous claim. So a no contest provision says, if you dispute my will, you lose the gift in the will. Now, this only works if they're receiving something under the will, right? So it tends to work better for people you want to support, kinda, but not everything. But a no contest provision, and I think this is important and valuable, will not stop a good faith will contest. If the person who is saying, I think this will is at issue, can show that there really were some irregularities, that won't cause them to be kicked out of inheriting under a will that is found to be valid. I'm going to pause. Any questions, Sarah, or listeners that we can address before we jump into tax planning and gifting?
No questions yet. And I just wanted to let everyone know, if you are thinking it's almost 7:30, this has been going on for a while, we are going to keep going. We're going to record everything. So if at any point you need to jump off, you will be getting this recording. Do not worry. You will not miss a thing.
And the end is in sight also. So I just want to give you some very high level tax planning thoughts. If this is you, I want you to think, oh, this is me and I should call someone. Washington State does have an estate tax. This is where I remind you that Washington doesn't have an income tax. You have to fund a government one way or another. The Washington State estate tax threshold is $2,193,000 per person, so a little over 2 million. It is not indexed for inflation. And what that number means is anything below that passes free and clear, no tax, no return. At $2,193,001, there is now an estate tax return requirement, and that $1 is subject to estate tax. It's a graduated rate between 10 and 20%. I use 15% as a back of the envelope calculation here. And importantly, it is not portable. So I have 2,193,000 of exclusion. My spouse Andrew has 2,193,000 of exclusion. Together, it's about 4.2 million. But if I pass away with 2 million and I leave it to my spouse, so he has 4 million, he doesn't get my exclusion too. He only has his 2.2-ish million, exposing that the excess to estate tax that we separately wouldn't have. So we call this the I love you will gotcha. Right? That's kind of the informal way we talk about it. And the most common tool to avoid this is to set up a tax savings marital trust. So instead of my 2 million and your 2 million equals 4 million, and now half of that's exposed to estate tax, you keep your 2 million. I'm going to put my 2 million in this tax saving trust that you don't actually own, although you manage it. It's there for your benefit. You can pull money out of it, but you don't own it. So that when you die, this is out of your estate and your 2 million is under the threshold. That was a very quick summary. I'm happy to dive into it more at questions. But this is something that is easy for estate planners to do. We do it frequently, and I would hate for you to just not know and miss the opportunity. Federal estate and gift tax impacts far fewer people. Right now, it's just short of $14 million per person, and it is portable. So the surviving spouse can take that initial $14 million. If you are in this federally estate and gift tax range and you don't have a will, you should get on that. Yeah. So reiterating, because of the tax trap, it's not just single people with 2 million or couples with 4. It's actually single people with 2 million and couples with 2 million. Need a little more attention. All right, gifting. So let's say you sit down with your financial advisor, with your estate planner, with your CPA, whoever you're working with, and you think, you know what? I think I'm okay. I'm set. I feel good about my life. I want to give some money to my family members now to help them, to charities, to whatever I want to do it. You can make your gifts outright. Cut a check, send it easy. Transfer title to the house, whatever. But you could also do it in trust. Maybe I want to fund my grandchildren's first home, but they're really young right now. I just want to put money aside for that purpose. That would be where you could talk more about a trust. Maybe it's that you know that this grandchild has behavioral issues or developmental issues, needs more care. That's what you could talk about a trust. For a gift and estate tax, unlimited deductions to charities and to spouse. Whatever you want to do, there's no tax issues there. But there's also very few tax issues between individuals for the majority of the population, the majority of us. So the gift tax return has what they call an annual exclusion. So this is the amount that one person can give to another person each year, each calendar year, with no gift tax return or no tax owing. It is indexed for inflation. So this year it's $19,000. And we already use our annual exclusion. This is what allows us to give Christmas presents and birthday presents without filling a gift tax return, right? What's interesting about this exclusion is it can multiply very quickly. So, let's say grandma and grandpa are happy. They're comfortable. They're thinking about estate tax. Maybe they just want to chip away at their estate a little bit to get below that tax threshold. So they give $19,000 to child A and child B. Well, now we're already at, I'm doing math in my head here, we're already at $38,000. Well, actually, mom gave 19 and 19, that's 38, but dad can also give 19 and 19. So now we're at 76. But let's say we trust their spouses. Now we can double that again because mom can give to spouse A and spouse B, and dad can give to spouse A and spouse B, and now we're at 152. For those of you tracking at home, don't judge me on my math. I don't do math on the fly. But you can see how this could add up very, very quickly with no paperwork requirement, no tax implications. People often ask, is there tax to the recipient? There is not. There is some capital gains considerations here. If I have appreciated Microsoft stock and I gift that, you take it with the appreciation, but that capital gains isn't owing until the stock is sold. So there might be tax implications, but there isn't tax owing just because of the gift. And this is why the bullet point about appreciated assets is here. It's something to be a little more thoughtful about, maybe involve some help.
We did have one question, Emma,
Yeah.
about the gifting and trust. They asked, my son is a minor, so I create a will and that will opens a trust when I pass. Is that correct?
Correct. So trusts in your wills, we call them testamentary trusts. They do not exist until you pass away. Now, for minors, this is really important. Just because a testamentary trust in your will does not exist, does not preclude it from being the named beneficiary of an account. So, and I have done this, my spouse and I have done this. Our will says, I'm going to set up a trust for my minor child because, again, he's not yet 2. And then our retirement and our life insurance names that trust. Banks don't love that. Sometimes there's a little bit of back and forth to make it work, but I think it's worth it in some situations, and the minor child is exactly one of those situations where it's worth the call to the bank. It's worth a little bit of back and forth to make that work.
Great, thanks.
Cool. On the topic of minor children, maybe you are eyeballing this gift thing. Maybe gifting makes sense for you, but you are not interested in giving said minor children or even young adults that money. But maybe a trust is too much for you. There are quite a few tools for that situation. So there's 529 accounts, which are income tax advantaged college education savings accounts. You give the money to the 529. There's an adult custodian who manages it, but it's for the benefit of the child. So it's a nice way to help the child, but don't put cash in their pocket. UTMA accounts work similarly. They don't have the tax advantage, but it's the same idea. There's an adult custodian. It's for the child. UTMA stands for the Uniform Transfer to Minors Act. You'll also see UGMA, Uniform Gift to Minors Act. And what I like about 529 and UTMA accounts is you can go to your favorite bank and say, I want to open a 529 account, an UTMA account, and they'll just be able to do it. You don't need to call me. You don't need to do a trust. You could probably open one online tonight if this feels like the right tool for you. So I like them because they're easy. There's also ABLE accounts. These are for individuals who became disabled before age 26, and it's to help them qualify for needs-based benefits programs. So let's say someone is born with developmental disabilities, they are likely to benefit from Medicaid or SSI, some other needs-based benefit. An ABLE account could be an elegant way to provide them support without messing up those benefits. On the topic of benefits, gifting, I love it. You know, pick your favorite charity, help your family members. If you are thinking that you are likely to want to qualify for Medicaid, gifting may impact your ability to do that. So if Medicaid is something that's on the horizon for you, Medicaid planning consults are available. Someone can help you work through that process. All right, last slide, charitable giving. You can always just give to charities. Do it, it's great. I love it, I support it. I encourage you to do it. There are other tools available that might be the right fit for you. So if you have an IRA or a 401k, you may know that required minimum distributions come out of that once you reach a certain age. Maybe you living off those required minimum distributions, it's the right amount, you're set, great. But maybe those required minimum distributions are more income than you need. So the cap right now for a qualified charitable distribution is $100,000. So I'll use that as an example. Let's say you receive your $100,000 RMD. Well, that's income taxable. So you receive a $100,000 RMD, but it's actually only $80,000 in your pocket. And then you turn around and you give it to the Swedish Foundation, the Fluffy Animal Society of America, your alma mater, whatever it is, they only get $80,000. The qualified charitable distribution cuts you out as the middleman. It goes straight from the institution as your RMD to the recipient charity, full $100,000. You don't get any income tax. You have met your requirement. That's a box check. For your RMD that year, the charity gets the full pre-tax value. So this can be a really powerful tool for people who have IRAs, 401ks, especially if they've been part of a really generous match program and they've grown. I'm going to skip donor advised fund for right now, stay on the IRA 401k theme. I also really love seeing charities named as beneficiaries as 401ks and IRAs. And that's because those distributions are subject to income tax, but charities don't pay income tax. So if you give your child a $100,000 IRA and then your charity a $100,000 gift in your will, the child actually only receives, say, $70,000 after tax, and the charity receives its $1,000. But if you swap where those gifts occur, the charity gets the full $100,000 IRA distribution because they're income tax exempt. The child gets the full $100,000. More of your money is ending up in the hands that you want. The other thing I like about naming charities as beneficiaries is you don't have to call me to do it. So maybe this year you name Swedish Foundation or the charity of your choosing as a 2% beneficiary. And then maybe next year it's a 3%, and the year after that it's a 5%. All of that can happen without having to call me, without having to call your CPA. We're not accumulating expenses for your charitable giving. And of course, you can always name a charity in a will or living trust. Donor advised funds can be a really great tool if you have, they can be a really great tool in all cases, but they can be especially great tool if your income tax years are inconsistent. They're a really great way to say, well, you know what, I always give X number of dollars, but I know that I want to actually, take advantage of the charitable deduction in this year because I sold that Microsoft stock. I'll take all the deduction this year and then I'll use that fund over the next 5 years for my charitable giving. The thing about donor advised funds is I do want to make sure the money gets out to the charity. So sometimes what I'll see is people will be putting money into their donor advised fund because they believe in charitable giving, but not actually getting their donor advised fund out to charities. So if that's the tool if that's the right tool for you, that's wonderful. But I do strongly encourage you to make sure the charitable recipients are getting the benefit of that fund. There are tons of ways to gift to charities. Another one that's not on this list that can be really helpful is charitable remainder annuity trusts. Let's say you have a piece of real estate that's highly appreciated. You bought it in the 80s and you're done. You don't want to live there anymore. You can say, well, I'm putting that in the charity. The charity doesn't pay income tax. I'm getting a little bit of an income stream out. The charity gets what's left. So where there's highly appreciated assets, special assets, there's as many ways to give as there are need and assets and want to do that. So if that's something that appeals to you, talk to someone.
We have a question specifically about gifting, just some clarification.
Of course.
Am I correct to understand that you can receive gifts up to $19K from each person, but it can be many different numbers of people, or does the gifter have to be related to you? Like, does it have to be mom, dad, grandma, grandpa giving you a gift, or can it be a friend giving you a gift? And then also, does the recipient does not owe any tax on these gifts?
Correct. There is no relationship requirement. If Bill Gates wanted to, he could rip out a page of the phone book and start cutting checks. I hope it is the L page of the phone book. So anyone, friends, godchildren, there's no recognized relationship with our godchildren, close family friends, things like that. No limits on those gifts. And then second part of the question was about tax to the recipient. Any estate and gift tax that might get paid is paid by the donor. So there's never estate and gift tax to the recipient. Gifts are income tax exempt, so there's not income tax to the recipient. It is almost 100% true to say that it's tax-free to the recipient. Other than, I do want to flag that if you gift a house, there's still property taxes. If you gift an appreciated house, that appreciation will get taxed at sale. So there's some pieces that pass with the gift, but no, if you give someone a $19,000 check, there's no tax on that.
Great, thank you.
Mhm. All right, last slide is just some information about me and my firm. This email address is incorrect. You can see where I didn't quite catch the edit there. It should be eluton, ELUTON at gth-law.com. This is the part of our presentation where if you have questions, please bring them forward. We are at 7:45, but I am comfortable hanging around as long as people are excited about it. So let us know.
Yes, thank you for the 10 attendees that stuck with us through all of this. I will start my video so you can see me again. And yeah, so we're just wrapping up our time together. If you have any questions, like Emma said, please let us know. If you have questions afterwards, you can send them to me. I can send them on to Emma. If you are interested in utilizing Emma, I would be more than happy to send your details her way for that as well. And if we don't have any questions, I just want to thank you all so much for being here today. Hopefully we'll see you all back on Thursday. We are going to be sending a survey. Oh, it looks like we have one question. Larissa has a question. Oh, Paula would like you to say your correct email one more time, please.
Of course. Correct email is eluton, ELUTON, and it's typed out here, my last name spelling, at gth-law.com.
Wonderful. Larissa, if you could drop your question in the chat, I will ask it. But yes, you're going to get an email with it. It's going to have the okay. Any thoughts on organizations such as People's Memorial?
That's not an organization I'm familiar with, so I would need, thank you, Alyssa. So I would need more details before I could offer thoughts.
I am also not familiar, so I will be unhelpful in that. And just wait a little bit. These folks have to type instead of talk. I think we're getting a little delay. Paula says, thank you so much. She's looking forward to Thursday. Okay, so you will get a follow-up on email. It'll have the recordings. So you will have that. You have sat through this all, but you can listen to it again, share it with your friends, and then a survey. We're always wanting to be able to do even more educational opportunities for our donors and caregivers like yourself who make all of our work possible and the work of Swedish Hospital. So fill it out so we'll know what the next opportunity will be for having a wonderful advisor like Emma on. It says the People's is a membership organization to assist in arranging final options, services, wills, etc.
Um, Not an organization I'm familiar with. One of the things I would want to know first is, are they local or are they national? I would want to make sure that you're working with an organization that is familiar with Washington law, Washington community property, wasn't selling the same services to different people with different needs.
It looks like there is one in Seattle, or at least there's a branch in Seattle, if it's not completely here. Um, I think, yeah, we might have to look into this a little bit more to give some opinions about it. It looks like there are some lawyers that are part of this group. So,
All right.
all right. Well, thank you all again, and we will see you on Thursday. Bye, everyone.